everyone, and welcome to Crime in Court. This is episode 95 of the Canton cover up series, Commonwealth versus Karen Reed. And we also talk about Aiden Turtleboy Carney. As you can tell, today is going to be a voiceover only. I am recovering from hip surgery, so I'm just kind of blah, and it's taken me, I can't do things like I used to, so I'm just going no camera today. So anyways, we are going to in this episode we are going to go over last week because I had hip surgery. I missed a whole bunch of stuff. It was the worst week possible to have hip surgery if you're covering the Karen Reed case, because I think there was something that happened every single day. So I'm going to go over very briefly last week in review, and then we're going to go watch and listen to the Turtleboy hearing. Listen to the Turtleboy hearing that was today. Actually, there were two hearings. We're going to get a recap from one of them and listen to the other one. I'll explain later. Let's dive in. Please hit the like button for me if you don't mind, as it does help the algorithm. All right, so let's start off with one of the things that happened earlier last week was Judge Canoni decided that she was going to allow the joint motion. So if you remember a little while back, we read a joint motion from the Commonwealth and the defense asking to continue the trial date to April 1st. This was allowed. So Judge Canodi did not rule on this in previous hearings where she had said, "I'm just going to keep moving forward, like we're going to have our trial in January," even though she probably knew realistically that wasn't going to happen. So they've moved it to April 1st now. And yeah, so April 1st is uh, a little more time for the defense to prepare and a little more time for the feds to step in if they plan on it anytime soon would be real nice. All right, so up next, what is the next? So there were a lot of court filings that kind of came out. Some of them had to do with Judge Canoni's orders. If you remember, we read through some motions, and we there was a motions hearing for the interview notes from certain journalistic entities. So like ABC, who did Dateline, Boston 25. So as you can see on this is a screenshot of the docket. And so on the 5th, Bev Canoni endorsed the motion for records WFXT TV Boston 25. After hearing and review of the pleadings, I find that the Commonwealth has met its burden of establishing good cause pursuant to Commonwealth versus Lampron. The motion is allowed. So she allowed that motion for Boston 25. And she put that order in memorandum and order. Also, for this one's for Gretchen Voss. So she's with, I believe, Boston Magazine. So this one, we also, it says decision of Commonwealth's renewed motion. Because remember, Adam Lally asked for this before the first trial. She denied it. This time around, she's like, sure, yeah, whatever, take it, go ahead. Even though there's no journalistic privilege apparently in Massachusetts, they do not protect their sources or their journalists, for that matter, from having their work product confiscated from them. So, yeah, they're asking for audio recordings, interview notes, email, text messages, voicemail, uh, in the possession of Gretchen Voss and Metro Corp. She's also Metro Corp Inc. is doing business as Boston Magazine and Gretchen Voss. So she was provided orders from Judge Canoni to hand over her work product. Next, we have another same thing memorandum, but this is for WCVB TV Hearst Television, which is ABC Corporation. Also, I'm gonna skip through there. The other things that are of note on this page is there was so on what was it? Boston Magazine on the 6th, she made the order, and by the 12th, there was an opposition of non-parties meaning it's not Karen Reed and it's not the Commonwealth, so they're not a party to this case. So non-party, Boston Magazine and Gretchen Voss are opposing handing over their stuff. And there was an affidavit. We don't have their I don't have the affidavit itself, but there was an affidavit filed from their attorney, the Boston Magazine attorney, and I'm assuming their argument as to why it is work product and they shouldn't need to turn it over is in there. So that is regarding the motions. Wait, am I missing? So those I'm missing one. I can't remember now. So who was there was, whoops, I just closed that on accident. There was another, whoever it is, I can't remember now. Because there were at least three motions, if not more. One of them was denied and the only reason it was denied was because they have no jurisdiction because their headquarters is in New York and not in Massachusetts. So there was one that was denied, and that was the only reason I know why. And then the other few were allowed. So this is another, what I have on the screen here now is another motion. This was from the Commonwealth. This was a motion for reciprocal discovery pertaining to the employees of ARCA. If you remember, the employees, or ARCA was hired by the FBI. So any discovery that the Commonwealth has, it's the exact identical discovery that they have. The both the defense and the Commonwealth, because there was a TUI motion, remember, that they requested pertinent information regarding their investigation into the investigation of John O'Keefe's homicide. So with that, there was over 3,000 pages of discovery turned over to both sides. But for some reason, Hank Brennan is like, "Oh, whatever, you guys are hiding something from us and we need you to turn it over." Basically is kind of what I'm thinking he's going for here. So I'm not going to read through it all cuz again, I want to go through this brief and there's a lot we got to get through. But this is the motion for the reciprocal discovery for the people that they already have discovery for, Daniel Wolf and Andrew Rentschler. These were the experts from ARCA that testified. So they're asking for all the notes, all the materials, not limited to an expert's report. Let's see, copy of all materials provided to ARCA or any representative of the United States Attorney's Office by any member of the defense team. So they are thinking, so it's like Hank Brennan is almost implying with all of this that there's something nefarious going on between ARCA and the defense team when the FBI hired ARCA. The defense team never got to question the ARCA team until trial. They they were not. There was a limiting instruction when the TUI report came out from the feds that they were not allowed to divulge certain information. But Um, yeah, it was in there. I forgot where I was going with that, but I think you know what I mean. Anyways, so I think they're trying to imply that the defense team and the ARC team have some kind of nefarious talk or communications going on behind closed doors or something. They're requesting all materials, written, documentary, video, what else? Describe and produce any exhibits to be used as a summary or a report. Describe all compensation paid. No, but Karen Reed's team didn't pay them. So what does it matter? And then all testimony, travel, blah, blah, blah. Provide any contracts, agreements, documents relative to Dr. Wolf and Andrew Rentschler. Provide all written communications between any members of the defense team and ARCA. Provide copies of all testing and crash test video, reenactments. Provide all written communications, including emails between the United States Attorney's Office and the employees of ARCA. I don't think um, that they have any right to that, but okay. The attorney, the AG's office of Massachusetts communicating with ARCA. I don't think that they have a right to that information. All communication between the U.S. Attorney's Office and any member of the defense team they're asking for. And yes, this was all from the TUI, provide all written requests, blah, blah, blah. And that's by the prosecution team, which I think is just ridiculous because they're asking for stuff they already have been handed to from the US government. But whatever. All right, next we have so I'm not going to read through this, but I just wanted to bring it to your attention as it's part of the updates from last week. So the defense team put out this opposition to the Commonwealth's motion to exclude the testimony of Dr. Marie Russell and request for a Daubert hearing. So they were trying to say, well, first of all, I agree wholeheartedly that they never should have had to bring in Dr. Russell for a second Daubert hearing. She had a Daubert hearing during the first trial while trial was in session. They sent the jury out of the room. They did a Daubert hearing. And Judge Canoni decided that she is an expert and she's fit to testify as an expert, but she limited her testimony to only dog bites. Well, now um, the Commonwealth wanted to bring her in again for yet another Daubert hearing. The reason is because she really hurts their case. Because if John has dog bites on his arm, then he wasn't killed by a car. Cars, as far as I'm aware, cars don't have teeth, so they don't bite human arms, as far as I know. So she really hurts their case, and that's why they're struggling so much with her. And I know she's not going to be the only one that they're going to try to exclude testimony from. When basically it's just trying to, incapacitate Karen from being able to defend herself. So all right, so I'm not going to read through this, like I said, but just I wanted you to know that this existed. And Robert Alessi, who is one of the newest attorneys on the defense team, he is the one that wrote this, and he also provided an affidavit to go with it. I will likely do another episode just on that, or at least on just the dog bite portion. I'll do something a little more tailored on that. But we'll read through that later because it's a 17 page or no, I thought it was a 17-page document. It's only 12, coming up 12. Anyways, so okay, sorry. So, up next, we have the endorsement on the defendant's opposition to the Commonwealth's motion to exclude the testimony of Dr. Marie Russell and request for Daubert Lanigan hearing denied. She just flat out denied it and says the court intends to hold an evidentiary hearing and the Commonwealth's motion to exclude based on Dobbert and Lanigan. So that did go on as they had planned, which was it was scheduled for the 12th of December, which was last Thursday. And according to this, I think this was filed the 10th, December 10th, it looks like. Their um, motion to in opposition to exclude her testimony and in opposition to even hold the Daubert hearing because she already had a Daubert hearing. So why are we doing it again? But as you see, Judge Canoni gave no reason other than deny the court intends to hold a hearing, and that is what they did. So they brought Dr. Marie Russell in on the 12th, so that was last Thursday. They did a hearing. It took just about all day. And part of that was because Robert Alessi, who was doing the questioning, he was very, very thorough in his questioning. I believe he did that on purpose so that he could make sure that they couldn't be like, well, she's not qualified because they really went over her qualifications in detail, a lot of her background in detail. She's qualified in emergency room, not just dog bites, but, all kinds of injuries and um, bites in general. She's an expert in ER trauma care, and from a medical standpoint. So she is very versed in this. They went through her background, and she's also a former police officer. She's kind of a jack of all trades. She's got a lot of experience in a lot of things too. So that was part of why it took so long. And then because that took past the lunch break. And then we came back from the lunch break on the 12th, and finally Hank got to question Dr. Russell. He was very abrasive with her. He was very rude, very like condescending, almost, and accused her in so many words of, lying about her testimony. And she like audibly gasped when he did that. Like, how dare you accuse me of not being truthful? Um, which is exactly what he accused her of. So he was very rude. And so now we got a glimpse of what Hank Brennan is going to be like when he does his cross examination. And he's not nice. And he kind of fights dirty. He fights dirty like Lolly. He's perfect for the Commonwealth. They found the perfect guy to try a woman that's already been acquitted on two of the three charges they're going to come at her again for. So, like I said, the hearing went on. Hank Brennan he was rude. He was, yeah, not impressive. He was not impressive at all. Um, I almost feel like he was trying to break her, like trying to almost make her cry or something. I don't know. Like she was fine and she held her ground and she was smart. There was a point of time when he was like, "Have you read any books about dog experts or by dog experts?" And he handed her this book and she looked at it for 2 seconds. She's like, "None of these people have degrees." Like everybody laughed. In the audience, it was hilarious because, yeah, some random Joe Schmo writes a book about dog bites, and this is apparently the guy that Brennan is bringing in as his expert. He was the author of that book that he handed to her that he doesn't have a degree for that book that he wrote. But and he's like a dog behavioralist, so very different. And Chloe's behavior has nothing to do with um whether Dr. Marie can determine if she looks at an injury or not and thinks that it's a dog bite. All right, so what next happened? Oh, before we move on, oh, another thing that uh Dr. Russell did with Robert Alessi when he was questioning her, he went through John John's autopsy photos, and not just that, but the photograph of his sweatshirt where it had the holes in it, and he basically had her go through like injury by injury and kind of determine like how you came to your determination so that they can't exclude her. So that's another reason why it was so lengthy, was because they were really thorough in that regard to try to get her to um, so that there's no way that Judge Kennedy can come back and be like, well, she's not an expert, because they've already met the bar. But for whatever reason, Hank still has a lot of questioning to go. And also, for whatever reason, Judge Cannoni won't let court go past 4 o'clock in the afternoon. So she let everybody go and said, let's reconvene on Karen's dime and the taxpayers' dime. We'll come back January 7th and continue this Daubert hearing of this witness who I've already let testify prior. So why we're doing this again? I don't know, but that's what's happening. So January 7th, 9 a.m., they're going to continue the Daubert hearing for Dr. Marie Russell, which is so frustrating and annoying for Karen that she has to continually go through this. I really feel like they're just trying to drain her. The system doesn't care. If you don't have money, you really are screwed. That's my take. All right, so another announcement that I just want to be really brief about was yesterday, so the 16th, there was an update in the docket for the SJC. This is regarding the appeal, Karen's appeal to the SJC. There was a status letter filed for the Commonwealth by a Caleb Schillinger, who's an ADA. So this particular person posted on X, KY Maverick 1, says a status letter is typically a document filed by attorneys to update the court on the current status of a case. So as soon as I read that, I was thinking, well, they just changed the date of the trial. So now the SJC, because we're still waiting on an answer from the SJC regarding Karen's appeal, now they know that the trial has been moved to April 1st, is what I'm thinking. This was probably a notification letting you know her trial will no longer be in January, but now it's April 1st. April Fool's Day, by the way. So he continues on saying this can include information about ongoing proceedings, recent developments, or any changes that might affect the case's timeline or handling. So again, that just sounds to me, or confirms to me, it's due to the timing having been changed. He says, I don't think he's asking for information, but rather probably advising the court of a new time or developments. We will see. I'm interested to see if it's anything about the jury foreman recently. Oh, wait, what? What the jury? Oh, not the jury foreman, but that 34 Fairview Road, that podcast that Turtleboy is part of, but not really because they kicked him out and totally are they there was a podcast. I don't want to get into all of it. There's so much drama going on, but there was a podcast by this one guy. The podcast is called 34 Fairview Road. He basically, him and his attorney friend reached out to Turtleboy trying to strike a deal on, let's do this podcast together. I totally believe in Karen's innocence. And then he totally turns around and makes it all about I believe Karen's guilty, and turns around and twists everything Turtleboy says. So this guy is now an enemy of Turtleboy. I don't know why people just become like total, they just turn on Turtleboy. This keeps happening to him. It's really crazy to see. Because it's happening with some other members of the Free Karen Read movement, which I'm not going to get into, but that was going to be one of my announcements, just that there's a whole lot of drama. So that's really all I'll really say about it. I try to stay out of the drama, but just know there's a whole lot of friction in the Karen Read movement right now because I don't know why. Everybody wants to take the turtle down, and I don't get it. All right, so the next announcement I have very quickly is there was a decision and order on the defendant's motion to dismiss. This is regarding the Duckgate incident. So Richard Schiffer Jr., he was facing witness intimidation charges just like Turtleboy and littering charges. Well, earlier last week, he went into court on December 9th. Arguments were heard from both sides, and the judge ruled from the bench and said, "This is stupid," just like every other person that has brain that isn't a Canton PD um, believed that wasting the Canton PD's resources for 6-month investigation on rubber ducks was probably not a wise choice for their tax-paying dollars. But that is in fact what happened, and this judge dismissed the witness intimidation charges. His littering charges still stand. I think they're going to hear that on another day, but I'm not really sure what's going to happen with that. Maybe if the Commonwealth had any sense, they would just drop them. But they're going to look. They did talk about something in their hearing, talking about trying to identify how often and how regularly the littering statute is enforced, because if it's not enforced or if it's only being enforced due to speech, then that's a problem. So they're going to look into that and I think reconvene. All right, so now let's get to Turtle Boy. Sorry that took so long, but I was out of commission all week and there was just a lot to go over. So this is a recent filing from the Commonwealth. This is their notice of discovery. So on December 10th, this is the discovery that they turned over to Aiden for his case, his witness intimidation charges. It says, now comes the Commonwealth in the above captioned matter and indicates that upon this court's approval of the accompanying assented to protective order, it will forthwith provide the following discovery to defense counsel. Number one, copy of text messages previously provided and referenced at the Karen Reed trial. There's 56 pages of that. So I wonder what that's about. 56 pages of text messages referenced at the Karen Reed trial. I don't know if it's Proctor's or what. A copy of MSP, Office of Professional Integrity and Accountability report. The 2-page document. These are all subject to protective order. So just about every one of these is. All right, so number 3, a copy of the Norfolk District Attorney Office Digital Forensic Device Report, 4 pages. Copy of a Cellbrite report, 3 pages. Copy of transcript of Dateline interview, 103 pages, including word index. Wonder if that's the Karen Reed Dateline interview, or no. Who would that be from? I don't know. That's confusing to me. All right, so up next, I don't know what the Dateline interview is. That'd be interesting to find out. It's not up for protective order, so I don't know. All right, copy of text message of victim witness advocate and witness. So text messages between the victim witness advocate, which was, I believe his name is Steve Nelson, and a witness, some witness in this case. It might be one of the witnesses in Aiden's case or Karen Reed's case, or both. Likely someone in Aiden's case. This is, that was subject to protective order. A copy of text messages from the victim witness advocate and witness, 3 pages, so maybe another witness or a different conversation. Copy of text messages from the witness advocate and the witness, 21 pages. Copy of text messages of DA Michael Morrissey and witness, 8 pages. You guys following along here? ADA Lolly and group text messages, 2 pages. Text messages from ADA Lolly and Trooper Tully. So Adam Lolly, and Trooper Brian Tully were in communications with one another, potentially, about what was going on with Tully and Mello, the prosecutor, the special prosecutor that was assigned in Turtleboy's case. Mello and Tully were in cahoots, basically, trying to entrap Turtleboy. Not just entrap, but like set him up to commit a crime that never was committed. So that was, they were entrapping him, but he wasn't doing anything wrong. But that is what they were trying to do that night before they put him away. And we have digital evidence of that, and that might be part of it. Also, a copy of a response to public records request, 217 pages, that was dated 11/25/24. So I wonder what that's from. Victim, witness, advocate, and witness text messages. Yet again, another communication inappropriate, probably, because why else are they getting it? And this is just what the Norfolk District Attorney's Office is saying. Yeah, this is what we'll admit to you we've done wrong. This is what we'll admit and hand over. This doesn't necessarily include any kind of oversight where there might be more communications that we're not getting. So that's that. And here's the protective order that all of those things are going to be under. Sorry, the dogs are running and being obnoxious right now. All right, so this is the protective order, motion for protective order regarding communication produced in the Commonwealth's Notice of Discovery of December 10th, 2024. Commonwealth respectfully moves, pursuant to Massachusetts Rule of Criminal Procedure for Rule 14(6), for this honorable court to establish a protective order restricting the public dissemination of all communications provided to the defendant on November 26, 2024, detailed in the Commonwealth's Notice of Discovery 51. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and victims' families. Furthermore, certain materials provided as discovery in this case may be evidence in an unrelated pending criminal case, like Karen Reed, or maybe some other cases that we haven't heard of yet, that there's just dripping with corruption. Sandra Birchmore, Justin Root, Enrique Delgado Garcia, Karen Reed, John O'Keefe, all of the Turtleboy, all of these cases need some oversight here, because Norfolk County is pretty corrupt. Furthermore, certain materials being provided as discovery in this issue may be evidence in an unrelated pending criminal case. The issue of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures, and as a practical matter to facilitate the discovery necessary for a trial. Comparable order for the same material is in effect in the case of Commonwealth versus Reed. The Commonwealth agrees that this protective order be set without prejudice, and they both stipulated to the protective order, and with that, Turtleboy will be able to receive all that discovery, but he can't publish it or post it or whatnot. So it might still take a while for us to find out what exactly he had turned over to him. All right, at this time, let's move over to this is what I wanted first. Whoops, hold on one second. All right, here we are. This is the first. Okay, so like I said, we only were able to see one of, or actually listen to one of Turtleboy's hearings. So he had two hearings today. One was with the fake victim. She, it has something to do with their phones and discovery in that. I don't know. And then he's going to explain that in a little bit more detail. This was his recap of that particular hearing. Then we'll go into the next hearing, which we actually will hear. So the first one was in district court, which they don't have video, I guess, and Supreme Court they do. So that's the difference, I guess, is what I just found out today. So the more you know. All right, so here is Turtle Boy's recap of his first hearing regarding the fake victim.
Videos. The incident that they are denying, rather, and we can't trust that they're the original videos. I mean, these are my kids. You know, they're hostile to me. They even wrote in their affidavits. They wrote in their affidavits that they want something to happen to me. They want me to be punished. So
he's talking about the McCabe's. Somebody, two of the McCabe's, I guess, handed over some video, but how can we trust that they didn't edit it in some way? Is what he's saying here.
How do we know that they're handing over the full video? What if after the video ended, you know, they show that she's long gone from there, or she has some sort of confession, or like they say something like, "Did anybody see Aiden? No, I didn't see him." How do we know that part wasn't deleted? We can't trust that the McCabe's just voluntarily handed over evidence, or if they had evidence that somehow proved I was innocent, that they would just hand it over on their own. They're perfectly capable of editing a video. So we need the original video. We need their phones, and more importantly, you know, when she reported that the car was vandalized, she didn't mention anything to the officer about a restraining order violation, which means at some point she had to be alerted about the video, that the McCabe's watched the video and they texted her and said, "Look who we saw. You know, he was there." And we need that text message. We need that because it proves that she lied in the police report when she said that I yelled liar at her. Every video so far that she perceived it, there wasn't a single video. I mean, people had cameras all over here. There wasn't a single video that showed me saying a thing. I did everything I was supposed to do. Like, you know, I was inside the courtroom. She came, I left. I asked the cop where to go. I stood there for 5 minutes. They came out. Apparently, I didn't see her. It was like, "Where's Waldo?" And, you know, scene cleared out. I went back across the street. Didn't even see her. That's not a crime. It's not a violation of any order. And it's absurd that we're even standing here right now.
So, couldn't have said it better myself.
Yeah.
I'm going to go talk to him about the 18th protocol.
Okay.
Want to meet inside over there?
Right here?
Like,
Right here.
send them free. Right there. And, yeah, let's meet over there.
I know.
We're not going to have time.
All right, so that's pretty much it for that one. Bear with me while I switch over to something else here. All right, this is the hearing. This is the one that we're actually going to hear the audio for. This is the motions hearing for Rule 17 motion. They're asking for, Michael Morrissey's emails and text messages and things from witnesses in the case. So here is that hearing.
Before the court number 3 and 4 on today's list, Kamal versus Aiden Carney, 23 CR 313, 24 CR 43. Mr. Carney is present and represented by Attorney Tim Bradle, who's present in court, and Attorney Mark Betterow, who is present via Zoom. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for various motion hearings. If the parties could
Crackling, sorry, I can't really do anything about that. That is part of the court's audio, I believe, or the court feed coming from the court.
please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Okay.
Hello, Your Honor. Timothy Bradle on behalf of Aiden Carney.
Hurry.
Person for the record.
Okay. Mr. Carney's here. Good afternoon. And Mr. Bedrow, you're on Zoom, are you?
I am, yes, Your Honor. Good afternoon.
All right. Before we call this case, it's going to take a little bit of time. Are there any other cases that need to be heard today? Nothing else. Okay. All right. Is there a natural order to things here?
My thought, thank you very much, counsel. My thought, Judge, was that I filed a notice of interlocutory appeal on Your Honor's ruling on the suppression, and I filed in connection with that a motion to stay the team procedure until the single justice can either accept the petition, deny the petition, refer it to the appeals court or the full bench, which I think would probably take, into about mid-January, Your Honor. And for the reasons that I cite therein, and I
Let me read it. Just
Sure.
hand it to me.
Just FYI, he's talking the taint team. He's talking about regarding the taint team is the Commonwealth has Aiden's laptops, tablets, phones, a lot of his work products from before they arrested him and confiscated all of his stuff. They, yeah, he wants his stuff back. They still have not done the search because of journalistic privilege, and so they're kind of arguing that as well in this hearing.
Just a minute ago.
And on that point, Judge, I don't expect.
Let me just read it. Let me just read it, because I'm going to.
Yeah.
Is there an opposition to it?
Yes.
Okay. Mr. Bradel, I hear you on it.
Thank you very much, Your Honor. So, Judge, it's really just a balance of harms issue in your discretion that, the government is poised to further search through Mr. Carney's remaining devices, whatever they haven't searched yet. And, there's very important things in there. There's about, Mr. Carney has about 5 or 6 other matters in which he has attorney-client privileged communications in his devices. He has journalist source material. The reason.
But I see, the next step is to get a tainting protocol. That's what we're going to do today.
Sure.
Either you have an agreement or you don't have it, and I'm going to enter an order.
Yeah.
Okay. I haven't
We did
seen
talk
any.
about that.
I haven't seen any opposition from you to the tainting protocol proposed by the Commonwealth.
Correct.
So I assume there's no opposition, and I should enter.
That is Judge Krupp that is speaking. He was presiding last time. It seems to be like we don't have the same judge each time, so they keep having to basically go over the background over and over again, but it seems like Judge Krupp knows what's going on, and he kind of gets it. There are times where you can tell Bradel's like really trying to explain something to him that he doesn't get about the severity of what Tim Bradel might be arguing, but other than that, I mean, he is pretty caught up in the case.
It. With respect to this motion to stay, all you're doing is seeking to stay the tainting.
Correct.
Right? I see no reason to do that because the DA is insulated from receiving any of that. You want to go up, you think you have a meritorious appeal, you'll take your crack at it. Sure. And if it gets stayed by the appeals court or a single justice, it gets stayed. But you're no more harmed by starting on the tainting process than not.
I do have a response to that aspect of it, Your Honor, is that, there's some very sensitive journalist source material in these devices. We're not sure, we don't have an inventory of what they've searched, what they haven't, but, my client receives source material from many people, and he is.
The question is, how are you harmed by starting on the tainting protocol, which is to have the devices searched for privileged material, and you'll give a list of keywords that have to be searched, and there'll be essentially 2 people that will have access to the devices and the data before you do.
No one, including a taint team reviewer, should have access to a journalist's confidential sources, Your Honor. That's our position.
This is one of those examples of Judge Krupp doesn't quite get the severity of it, so Tim Bradel basically has to explain, like, well, the people that are part of the taint team, what if they're part of the people that are the whistleblowers that are out there, um, trying to stop the people that are trying to stop corruption? And what if there is some issue in that regard? So the people doing the searching might in fact be the people that you wouldn't want doing the searching, if you know what I mean. That's kind of the point that he's arguing here is like, how do we trust the taint team when it's made up of Commonwealth individuals?
These people are civilians, police officers who volunteer information, whistleblowers who give my client information about all sorts of people. And in this particular case, Judge, there's a very important issue at stake, which is that
That's what the taint team is for. That's what the taint team is for. The taint team is going to review these devices for that kind of information. Now, there's a question as to whether the taint team is set up for anything other than the attorney-client privilege, but you're going to give a list of names and sources or other things that you want segregated from the Commonwealth. That is to say, the Commonwealth can't see, and that process ought to begin, it seems to me, and there's no harm in beginning that process. Certainly no harm to your client or sources.
Well, Judge, the harm is that people have, given Mr. Carney very sensitive information, and here's the important part, about these very same investigators that are going to look in his phone, that are going to try to look in his phone.
The proposal is retired Judge Macy and I forget the other person, the person named Verano. I assume that neither one of them are involved in this investigation. Is that correct? So this material is not going to fall into the hands of the very police officers that you're talking about. It's going to go to the taint team initially, and it's going to be controlled. Taint team is going to be controlled by the court, and you're at some point going to have to review the work of the taint team.
The problem is there's never been a judicial review of the journalist issue. There's never been a pronouncement from the appellate court.
So if there is any journalist issue, if preventive medicine's taint team protocol covers First Amendment sources, we're going to have to tee that up. That's to say, it's going to have to go to a taint team. You're going to have to specify who the sources are, or whatever else, whatever keyword we have to figure out. That's going to come before the court, and the court's going to have to make a determination about whether that should or shouldn't apply. Okay, right now, you're proposing to have me adjudicate something in a vacuum. I have no idea if there's source material on there. I have no idea if there's anything on there. Okay, and
Mr. Carney has provided in past pleadings, Your Honor, an affidavit to that effect, and I can get that to you. It's probably buried, 20 documents back, but I'll get that to you. But there is an affidavit in the court's record about what's on these phones. And just while I'm on that point, Judge, we have asked for the phones back a number of times, and I can show you that too. But I don't think it's determinative in your.
Yeah, it's been over a year that they've had his data, his devices. They won't return them. All they have to do is make a copy of them and give them back. And they haven't done that. And part of that is because this whole taint team thing, and they want to get this figured out. But part of that has been Mello being MIA for a while too, and trying to not be accountable.
Your court's ruling, in your ruling about this suppression, but the idea here, Judge, is that, well, first of all, I appreciate you narrowing the issue to just who gets to see these source materials. Should a taint team person see such sensitive things? Let's say a police officer that works with these investigators that are chomping at the bit to get into my client's phones. Let's say that investigator works with these people and is a whistleblower about certain misconduct that may or may not have been reported on yet. Or it may have been reported by Mr. Carney already in a confidential way. It may be a future story. Whether that should be looked at by anyone else hasn't been litigated, Your Honor. And that's the part of this that's so important, that needs a full hearing and needs review by an appellate court, that, that these source materials are dangerous and sacrosanct. And Massachusetts, as I know you know, is kind of behind the eight ball on protecting journalist material. There's no statute. There's meager case law that I gave you last time. It's nonetheless, the First Amendment protects journalists. The Pentagon Papers case, Your Honor, protects journalists. There's sort of a piecemeal quilt of protection. And I think it's about time, and this may be the case, where the SJC, the single justice, or the full bench can say journalist materials need to be protected, Your Honor. We know that.
Yes, this is the case of all cases to make that happen in Massachusetts, because they have definitely weaponized the Department of Justice against journalists. As you can see, they've done it trying to get journalists interview notes and things during the Karen Reed interviews, and now with Carney and keeping his devices for 14 months now. And they took him in October of last year. So we're going on 14 months of him not having his devices where he did a lot of his work, and all of his work was on there, and his sources and source material that, if it ended up in the wrong hands on the side of bad, bad things could happen to that person, perhaps, if that got out. So it needs to be, this needs to be the case that SJC opens their eyes and says, hey, let's make a change now because this is the problem.
Attorney-client things are not quite as sensitive in terms of somebody putting their career on the line, putting their life on the line to give information to a journalist.
We don't know that for a second.
Well, it could go either way. That's really more to the point, isn't it? That we have to figure it out. And, people risk their jobs, people risk everything to blow the whistle on corruption. And that's what Mr. Carney receives time and again. And his track record, you may not like it from one perspective, but from another perspective, I know you're a fan of the First Amendment, and Mr. Carney has an unmatched track record of scoops, of revelations, of uncovering corruption. That's why he's sitting here, Your Honor. So these are incredibly important issues that to ask for 30 days to have a single justice evaluate the same arguments I'm making to Your Honor is really not a ton to ask. It's just some time to allow me to get the brief to the single justice, let my brother respond, and let's see if we can actually generate some important case law, some appellate precedent that can.
All right, so just in case you're having trouble keeping up, I know sometimes I do, so it's good to have someone else explain it. So Tim Bradel, Aiden's attorney, is asking for 30 extra days. They've had Aiden's stuff for 14 months now. So what is 30 more days? They're asking for 30 more days for him to get a brief to the SJC to discuss this whole, or to be able to argue against, this is why journalistic privilege needs to exist and why we need to be able to protect our journalists and their sources. So he's asking for that time to go in front of the SJC to file a brief, to have the Commonwealth respond to that brief. And he's not met with a very receptive judge, let's just say.
Can give us some guidance on what to do in this situation and to give some protection to journalists.
All right, let me hear from Mr. Cosgrove.
I have just two brief comments. One is it may be that an affidavit setting forth all of this has been filed somewhere and I've missed it, but my memory fails me as to seeing this so far as I recall. These have just been representations of counsel who I assume have not been through Mr. Kearney's materials. The other thing I would say is this is not a promising interlocutory appeal by the usual standards.
And that's his opinion, and that's really not for him to decide. This is Cosgrove, Robert, I think, Cosgrove. He is the Richard Cosgrove. What is it? I can't remember now. It's something Cosgrove, and he is representing the Commonwealth while Ken Mello is out sick, and he does address that also in this hearing.
One of the most significant factors is whether any harm can be remedied in the ordinary course of appeal. And of course, we know that if there's a failure to suppress something that should be suppressed, that's classically something that can be remedied in the ordinary course of appeal. So I don't think, candidly, that Mr. Bradel's chances of an interlocutory appeal are particularly good. And for the reasons Your Honor has articulated, I don't see that we lose anything by going forward on the taint protocol, because we're talking about, frankly, a several-month process before anything is even turned over to the Commonwealth. I would suggest that Your Honor deny the motion. I'm happy to hold off for 4 or 5 days. If Mr. Bradel wants to appeal Your Honor's denial of his motion to his stay to the single justice to give him time to do that. But I think the proper action is to deny the motion.
For the reasons stated previously, I agree, and I'm going to deny the motion for further, to stay further search pending interlocutory appeal.
So Aiden lost that one. He is going to the paint team process is going to begin, even though they just asked for it to stay for 30 days. They wanted the opportunity to go to the SJC. He says no.
So just so I have it right, your position, you're holding, your fact-finding, Judge, is that those source materials and attorney-client privilege materials will be protected through the taint team protocol?
We're about to get to the taint team protocol.
Okay.
We're about to get to it.
All right.
I endorsed the Commonwealth's revised proposal for examination of digital materials, docket number 53 in docket 23313, back at the beginning of this month, that the court will take up this motion at the hearing today, 12/17. The parties will discuss the proposed protocol in an effort to resolve any differences before the hearing. Any opposition to this revised protocol shall be filed by December 13. Did you file an opposition?
No, Your Honor.
Okay. So I should adopt this proposed protocol?
Your Honor, we have,
Did you discuss it with Mr. Cosgrove
we did, excuse me, Your Honor, sorry, we did.
after the last hearing?
Yes.
Okay.
So we talked about, or I raised 3 issues, Judge, that are not covered by the government's proposal. The first was that whether other privileges would be honored by the taint team through keyword searches, and I think they will do that if we're giving keywords to them that involve journalist privileges and so on and so forth. Obviously, it's impossible to give keywords about source material without ringing the bell. So, you know,
The keywords are disclosed to the court, right? And the court's going to provide them to the taint team under this protocol.
right. So you can see how problematic it is that there be generated a list of keywords that are potentially related to source material.
It's basically like them telling on themselves, like these are our sources or the topics that we don't want you to look at on our phones. They're basically doing like a search for all of the protected material to keep that out of the search. So if that makes any sense. So they're basically giving the same individuals that have been brought on through the Commonwealth representatives, they're going to give them all of their basically source information that they don't want given over to the Commonwealth. You see how problematic that could be? If there's a person in there that shouldn't be trusted, they might be handing that over to Michael Morrissey in the end. Do you see why? Do you see why Aiden might be nervous about a taint team? I would be.
So, you know, that's one of the issues that we object to. The second issue that we want to deal with is that the government is specifically excluding from potential search terms any communications relative to the attorneys in the Karen Reed case. And we would object to that, Judge.
Because there's an attorney-client privilege between the attorneys and Mr. Kearney?
Well, there's a joint defense issue, Your Honor, that they're both.
So it would predate any jeopardy to Mr. Kearney. So communications with them predating any jeopardy to Mr. Kearney would not be covered by a joint defense. It would only be after Mr. Kearney was charged that there would possibly be a joint defense.
Well,
right?
It's a little more complicated because we know that he was under investigation along with Ms. Reed without any resulting charges.
We know that in earlier this year, actually, they went to a grand jury trying to indict Turtleboy and Karen Reed on conspiracy to intimidate witnesses. So they were trying to link them somehow together to this witness intimidation statute. And the grand jury did not find any reason to indict them. They did not indict them. So um, it didn't go anywhere, obviously. But yet they're still trying. The Commonwealth would absolutely still try to take them down on more charges if they could. And so that's another problem, going through their phones, going through his phone. Just, stuff you might want to be concerned about when you've got a crooked government looking at your devices.
So we would contend that does fall under the umbrella.
Hang on one second.
His phone's ringing.
Live question, whether or not there's a joint defense umbrella on that.
Do you have a joint defense agreement?
We don't have an agreement, but there's an implicit, there's been an ongoing, long-term implicit mutual assistance and mutual defense that I myself have been a part of for a long time, and Attorney Bedro has as well. And it's an issue that is not able to be worked out.
I really have no idea what that is. That means, are you asking me to make any particular, let me ask you, on the first issue, are you asking to make any changes whatsoever to the proposed protocol? I'm looking at the motion, which is docket number 53, indented paragraphs numbered 1 through 10 on pages 4 to 8 of that document.
Judge, what I would ask, Your Honor, is that you give us a little more time.
No, today is the day. Today we're doing the taint team. I specifically ordered it 2 weeks ago. If you wanted to submit an opposition, you could. You didn't. So I'm going to act on this now, and I'm bending over backwards to accommodate you here, not having filed an opposition, and I'm hearing you on any potential changes that you are suggesting need to be made to this protocol. Well, but I'm not hearing any specific ones.
We filed a motion to stay.
And I denied that.
Right.
So the next question is?
I am now asking for time to respond to some of the more detailed issues.
That's denied. Okay, I set a schedule for dealing with the protocol 2 weeks ago, and it was to do it today. So hearing no specific proposed changes to this, I will adopt the proposed protocol. I'll need to get a copy of it in Word form so I can adapt it into an order. So if I can get docket number 53, maybe I already have it in Word form in some email someplace, but I'm going to need it in Word form. Okay.
Thank you. I'm just going to say, this judge is kind of a dick. But you know what? I don't have a whole lot of respect for a lot of the judges in Norfolk County, so, What happened? Why did it stop playing? Oh, there we go.
Okay. There was a motion to compel Rule 14 discovery that was filed by the defendant, and 2 weeks ago I entered an order that required the parties to confer about that and to let me know in writing by last Friday if there were particular requests that were sought. I don't believe I saw a letter requesting any additional discovery.
We have conferred on that,
Okay.
Your Honor. Two things. I did file a motion for a protective order with respect to some discovery responses to that I'm prepared to.
So I got the Commonwealth's notice of discovery on December 10.
Right.
And there was a motion for protective order regarding communication produced in the Commonwealth's notice of discovery of December 10. That's how it's captioned.
Yes.
And I signed that back on December 10. Is that what you're referring to? Maybe it wasn't docketed in the signed form. I don't know.
I think it probably wasn't docketed. Or
Let me just give this to you and make sure this is the right document that you're thinking of.
it sounds like the right thing. Yes, thank you.
There is something docketed as docket number 55.
Receive a copy of this, Mr. Gray. I know you saw the original. Did you receive a copy of it endorsed?
No, I don't believe so.
All right, so you folks can take a copy of that today. We'll get a copy for you.
Probably a flaw in the way I filed it, Your Honor. So in any case, I'm going to turn all that material over to Mr. Bradel.
Okay.
I'm aware that the court has executed the order, and thank you. There is additional discovery involved in terms of the the search of the iCloud for the district attorney's records, and search of some of the employees of the district attorney's office, which is in progress at the moment with the Karen Reed team. I have conferred with them and will provide them with additional search terms that are specific to this case.
This is a so-called Proctor discovery?
Yes, and also some of the other offices that are involved. Most of the search terms will be identical to those that the Reed team is using because, with one or two exceptions, the alleged victims on the indictments that are before Your Honor are the witnesses in the Reed case. So it comes out to the same thing, but there are a few additional names. I'm going to submit that. Once the search has been done, I will review all of the documents and turn over all the Rule 14 material to my brother. I expect that's going to take probably another 3 weeks.
Okay. And you have a date in January for another hearing on the issue with respect to Mr. Mello.
Yes. And with respect to that, Your Honor, I have to tell the court that I don't think Mr. Mello's health is going to permit him to attend that hearing. So I don't know what Mr. Bradel wants to do, whether he wants to try and go forward without Mr. Mello, whether he wants to get another date, or whether he wants to use it for some of these other issues that we've talked about.
So they're supposed to be arguing the motion to recuse Ken Mello, which has been pending for 9 months because Ken Mello has been MIA this whole time. And the hearing to argue that, he's telling Cosgrove right now is telling us, oh yeah, by the way, Mello's not going to be able to make it to his own hearing about his own conduct in this case. Interesting, huh?
Is this your motion, Mr. Bradel? I don't think I went back and read that motion. What are you seeking to do?
Yes, there's a motion to disqualify Mr. Mello for a host of reasons, Your Honor, and that's been pending for a long time. So
When did you file it?
9 months ago, 6 months ago,
Okay.
and then since
And
my
it's
filing,
opposed?
Yes,
But Mr. Mello was not able to get here and is somehow impaired.
that's correct.
Okay.
since my
Do
original
you
filing-
expect him to try the case, or that he would be involved in the trial?
A lot depends on his prognosis, Your Honor.
Okay.
So at this point, I could not say one way or the other.
He should be recused and made a witness because he was conspiring with Tully and the fake victim to get Turtleboy arrested. So he should be a witness in this case, Ken Mello. That's what should happen.
Whether Mr. Mello is going to continue, whether the district attorney is going to find another person, or whether I'm going to wind up doing it. I couldn't say it at this point. I'll only tell the court that I'm proceeding as if I'm going to be the trial attorney.
Why does it matter to you whether he's disqualified?
Well, he's a witness, Your Honor. We originally filed a motion for other reasons, and, they're readily apparent in the record there, Judge, and, I think it's just going to belabor the hearing for me to get into that. Part two of that, as that motion was pending for months and months, it became apparent that Mr. Mello is a witness in the case, and he's been communicating with the complainants on his cell phone exclusively, and he's definitely going to be a witness. And we filed, again, papers to that effect. That's part two of the disqualification motion. That's probably the low-hanging fruit on it. The easy way out is that he's a witness. And
Okay. You want me to leave the hearing on for January 10?
at a minimum, we can address some of the other issues that are coming up in terms of discovery on that date, Your Honor. And if maybe, who knows? I don't know what his health situation is, Your Honor.
Well, we have 2 weeks in that, where very little is going to get done at the end of December. Does that give you enough time? Does that give the DA's office enough time to deal with the iCloud issue and the documents with regard to others in the DA's office?
I think I'm going to need 3 weeks anyway, Your Honor.
Yeah.
I think we'll have some business to attend to that day if you want, Your Honor. We'd like to just kind of keep the ball rolling. If
We can leave it on. We can leave it on. We may have things to discuss about the team's work, because if I enter this order today, we have to figure out things like, has it been abided by? So we're going to need stuff from you to make sure that the taint team process works and there's a schedule for that.
Your Honor, if I could just backtrack for a second. I filed that motion under the optimistic assumption that it might be acted upon the last time. And I think there is a date in there for compliance in one aspect by Mr. Gradle that will have to be amended. I'm sorry, I take that back. I was thinking of the motion filed subject to impoundment.
Okay.
I'll say
Yeah, I don't
that
see any dates. All the
A little
dates that are in the taint team protocol proposal all seem to be keyed off of the date that the order is signed.
very good.
Okay? All right, you're on for the 10th. Anything else?
Yes, I'd like to be heard on the motion Mr. Gradle requested the last time that we were heard on at sidebar. I'd like to be heard on it at sidebar again, and I'm going to ask that conversation be impounded.
So they want to have a sidebar conversation that is impounded, basically sealed from the public. So this is, again, most likely they are talking about Michael Morrissey's email and text messages and things that they don't want on the record. So, yeah, they have a sidebar conversation that lasts about 10 minutes. So it's a pretty lengthy conversation, and we're going to skip forward here. And it's going to end very abruptly when we get back to it. So just be prepared once I get to the right timestamp here. Whoops, sorry. Here we go.
I think that's everything the Commonwealth wanted to cover, Your Honor.
Okay, Mr. Bradle, anything else?
All set, Your Honor.
Okay, thank you.
Okay, we'll see
Thank
you
you.
January 10th at 9 a.m.
January 10th, 9 a.m. And now we're going to go back to our stream outside the courthouse. So, I forgot to mention the stream where we actually saw Aiden and his attorney Tim Bradle speaking on the courthouse steps. That was Seeking Justice with Tommy and Boston Mike. That is the name of the channel. It's Tom CPU and Boston Mike. They have coordinated efforts to streamline the streaming of these hearings, which has been just amazing. So we are going to skip forward in this particular one. Don't worry, I'll fill the screen over in a second. I just want to get to our timestamp. All right, let's, there.
Wanted the judge to let us get to the SJC and litigate these issues because we really need an appellate decision on this stuff. So we're working on that. We can still appeal. It just means that this protocol is not stopped while we appeal. So, and again, the protocol is designed to protect everything in Aiden's phone from the wolves out there who want to get at it. So it's, we were going for the kind of the brass ring here, but we got it. It is where we want it to be anyway, and we're still going to appeal. We're still going to try to get some case law made about protecting source material, protecting the First Amendment, protecting Aiden, so that people who, give him this sensitive information can be confident that he's not going to get, bundled by the cops and forced to give it up. I mean, that's stuff right out of Stalin, right? So anyway, thanks, guys. Thank you. The most important thing that came out today is that Tim and I and Attorney Better had a long meeting with State Representative Nicholas Boldiga, and we discussed how he will be crafting legislation to overturn the witness intimidation statute, and there will be public hearings held on this because it's blatantly unconstitutional for a statute to exist that says that your speech is no longer legal if somebody subjectively says that they are experiencing emotional harm because of it. So that's to protect journalists. To protect journalists. He's going to file another statute to put something on the books to protect journalists and source material and sources.
Awesome.
So that was very encouraging. So none of this would be going on if this statute didn't exist. It's unconstitutional, and we're going to overturn it one way or the other. Yeah. So
What about Mello?
what about your guess is as good as mine? I don't know.
That was Tom CPU who said, "Where's Mello?" But so there you have it. They're working with the state representative to overturn this unconstitutional statute of witness intimidation and to create a statute or some kind of law that go into effect to protect journalists and their sources, which is very much needed in Massachusetts, apparently. So yeah, that is some good news there.
It's gone. Weekend at Bernie's. I don't know. Like he must really want to stay on.
And his stuff in a plastic popcorn bag. You notice that? It was a popcorn bag. Anybody else notice that? Yes, yes.
Thank you guys for coming. Appreciate
See you
it.
later. Take care.
All right, so there you have it. That was Aiden, Turtleboy, Carney's hearing today, and a lot of recap of what happened last week. Sorry there was so much and I just missed it all because I was trying to recover and give my body some rest. I'm still not, able to sit up all day and whatnot. So it's still a little rough. So I'll be returning probably intermittently as I can, but I just wanted to make sure that I got this to you guys because there was so much that happened last week. So let me know what you guys think about this case, about what's going on with Turtleboy and Cosgrove Mellow not being available again. That's just crazy. And the judge getting so frustrated. I just don't understand. Like, if anybody should be frustrated, it should be Turtleboy. And why the judge is getting frustrated at them when Commonwealth has had months with his devices and haven't done anything. So it's comical at this point, but it's sad at the same time. And especially if you're Turtleboy, it's not funny because you're living it. So, but it's comical from the sense of what more corrupt stuff will the Norfolk County of Massachusetts commit? It's just one of those things. We're all like, I can't believe it, but I can type of situation now. We don't, we believe anything is possible from these corrupt people. So, on that note, I will let you guys go. Thank you so much for watching. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.